Ms. Day is present. Good morning.
Good morning, Ron.
Mr. Eastow is present. Good morning.
Good morning, Your Honor.
So is this appeared like it's some sort of agreement as based on what I could see in the record?
Right, we're working in that direction, Your Honor. Ms. Rowland, the petitioner, was supposed to file a petition for minor guardianship, just a regular petition. And then I was going to prepare an order of agreement by the parties to visitation and so forth, recommended by Ms. Day and agreed to in principle with everybody. My client is here, Christina Betters, but I don't know if Ms. Rowland is here or not to update us on the status of the petition.
I believe she is present. I think I saw her here.
I'm here.
There we go. Good morning.
And the full petition has been filed.
It has. Okay. I haven't received a copy of it yet. So
It looks like that was filed December 22nd.
no. Okay. I guess I should have gone on Odyssey and looked for it, but okay. Well, perhaps we could set this over for a couple more weeks for me to prepare the final order. So that would give me time to get the copy to everybody and look it over and make any changes before we get it entered.
All right. I have a question, Ms. Day. Did you, maybe I missed something here. When I looked at this one, there was some criminal history that was concerning. Did you find that in your report?
So there was a criminal history involving the petitioner that was very, very old, if I remember correctly, if I'm not mixing this up, and that's been resolved. There's the mother on this case. The father is alleged he's never established paternity, and the parties have agreed to the stipulation that would allow for regular contact with mother, similar to what they've been doing primarily over the last few years. So the child is doing well in the home. Grandma's providing well for her, and the child has a good established relationship with her grandmother, her mother, the alleged father, as well as various other family members.
Okay. All right. So, Mr. Issa, how much time do you think you would need in order to prepare final orders?
Just a couple of weeks, Your Honor. I can get them done this week and out to everybody for review and comment, and then we can be ready to go in 2 weeks from today if that's good for everybody else.
That works for me.
And Ms. Rowland, does that work for you?
Yes, that's fine.
All right.
That works
So,
for me.
okay, thank you. So what I'll do then is I'll continue this out to the 16th at 10:30. And then I'll do, right after docket, I'll do an order extending to that point. So we have an order in place.
Okay.
Your Honor, if this is all agreed and signed, we could then potentially strike that hearing and just forward them to you ex parte to be entered, correct?
As long as we can get that done prior to the 16th, just so we don't have a gap. Maybe we should, if you'd prefer, we could go to the 23rd, and that would give a little more leeway. And again, we could just strike the hearing once that order's entered.
I think that sounds fine.
Yeah, I agree with that.
All right. So let's extend it out then to the 23rd instead of the 16th.
Okay.
And that'll be at 10:30 unless it's stricken by an agreed order. So, and I'll apologize to everybody. I'm coming into this. I have not been handling this case up until this hearing, so I was able to review through the case to kind of see where we were. And I see do we have Miss Barr is present. I guess my question is, the mother present?
Mm-hmm.
She is. All right. And ma'am, are you waiving service in this case? In other words, are you agreeing to, I can't hear you. I can just barely hear that. There's
Your Honor, I'm happy to give you a brief summary.
Thank you.
okay. I guess my concern on this, I'm assuming this looks like service was accepted by somebody else, which wouldn't be a proper service for the case. That's why I'm asking whether she's waiving service to move ahead. So Ms. Granitz, if you can hear me, if you can give me a thumbs up that you're willing to go ahead and proceed at this time. I'm not getting any audio, so if you could just hold your thumbs up or thumbs down if you're ready to, if you want to go ahead and proceed today.
I actually said proceed to what? Is that what you said? Yeah.
Well,
she doesn't know. proceeding to.
Okay, well, whatever we're working on today. So, Ms. Farr, maybe you can give me some history on this.
Yes, Your Honor. So, mother did agree to accept service through father. Father went to the attorney's office to accept service for both of them. They have both filed consents for the temporary guardianship only. And my report was due today. We were planning on entering orders today for the 60-day emergency order. However, because of the holidays, I was not able to get my report completed. So I'm asking the court to give me one more week to get my report filed. I did talk with Mr. Rosenberg last night, and he agrees to give me that extra time.
Yes, no objection on my client's part.
All right. I didn't see any consents in the file. When were those filed?
I can tell you, I filed them myself. So perhaps they're still en route.
The last thing I have is an appointment of resident agent that was filed December 20th.
Hmm.
And I have on the 19th an order.
It is possible that I still have them in my file and was planning on filing them with my report.
Okay.
But I don't have that in front of me, so I can't confirm, but I'm thinking that's probably the case.
All right. And you had a chance to look into the criminal history in this case. This was originally denied due to criminal history issues.
Yes, and I at the last hearing, I explained to Commissioner Carmi that I will be explaining those some of the criminal issues for the proposed guardian in my report, because I didn't believe it should be broadcast through YouTube.
Okay. That's perfectly fine. So everybody's in agreement to set this out a week. Is that what I'm understanding today?
Yes.
All right. And Ms. Granitz is nodding her head in agreement. So I will take that as an affirmative. So we will, do we have a temporary, what I'll need to do is extend this one out a week as well then. Is 1 week going to be sufficient, do you think?
Yes, Your Honor, I'll get it off to the court in the next day or two in the mail, and so and to all the parties.
All right. So I will extend this to 10:30 on the 9th of January, next Tuesday, and we'll look at the report and we'll go from there.
Actually, I apologize, Your Honor. I am not available the 9th, and I didn't look at that date.
Okay. You want to do the 16th?
The 16th, please.
Does that work for everyone else?
Yes.
All right, so I'll do it to the 16th, and it'll just be a mirror the order that was signed by Commissioner Carmi on the 19th. Okay.
Thank you, Your Honor. And so, Your Honor, are you presiding on the Tuesday dockets then going forward?
That's a good question. I believe so. I have a new schedule, and today is the first day of it, so I haven't got it all committed to memory, but I believe that is the case going forward.
Financial
Thank you.
declarations. My client's the responding
You're-
party.
Thank you. All right.
We're going to match what they do. They're supposed to lead the way. They're making this request. They have to produce the evidence. It's their burden. And they didn't do it. They didn't meet it. And it should be noted, counsel represents that the parties had a joint account that they both contributed to. Wife has stopped contributing to that account, and my client's starting to freak out because he doesn't know what he's going to do now. She has changed her direct deposit. Given wife's mental instability, we request that her motions be denied and that my client be allowed to move back into the house and each pay their own attorney's fees. My client's income that I was able to establish, he's netting right now about $3,500 a month. She's likely grossing, based on those tax returns and a cost of living increase, about $5,833. So their incomes are about the same. This means, in fact, there is no basis for spousal support. Access to documents. Your Honor, she got a new phone after they separated, and she's claiming that these things are still happening when my client has no access or information about this new phone, new carrier, new plan. It doesn't make sense. Their allegations are empty and baseless. And then she talks about getting documents. Well, she's been in the home, so she must have had lots of access to documents. My client's not deleting anything. He's not tech savvy. He doesn't know how to cyber stalk somebody. He doesn't know how to set these things up. So I don't know what to tell you, but the court can't issue a restraining order based on baseless allegations that are not supported by documents or evidence. So we are requesting that both motions be denied, and that my client be allowed to move back into the home.
Counsel?
Just briefly, Your Honor, as it relates to my client's options for housing, both parties acknowledged that my client was residing with her mother across the street, and both parties acknowledged that this wasn't a long-term plan. In Mr. Miller's responsive materials, I'm not sure if it was the declaration that Your Honor had the opportunity to read or not, but even in his own statement, he indicates that my client's mother had contacted him, asking him when this was going to be over, because essentially she couldn't handle having her daughter in her own home. So to state now that my client could easily move back across the street with her mother and bring her 4 cats with her, I think that's disingenuous. Obviously, there's a lot of issues before the court. More discovery needs to have been completed, frankly, before any final orders in this matter. But what has been provided, at least on a temporary basis, shows that my client does have a need, that she needs to remain in the home with the cats. And again, Mr. Miller has failed to provide anything by way of documentation of his need to return to the home. So I ask the court to consider that as well.
All right. Well, I'm going to defer any financial findings over a week because I don't have a basis for allocating any of the, I don't even know what the house payment is, frankly. So I don't know what people's incomes are, what their expenses are on a monthly basis. So I really am not in a position to make any financial orders. I don't know, maybe they both have large bank accounts. I assume they don't, but I don't know that. I just don't have any information about any of that. So I'm kind of at a loss to be able to make any rulings with regards to finances today. In order that both parties pay any bills that are in their name going forward and any new bills that they acquire, because that would be a normal order of the court, and neither party should make any changes in insurances or those kinds of things. Training order is problematic. I mean, I don't know that I have at a preponderance level sufficient evidence to order a protection order level of restraining order. I think it's appropriate to enter a do not, it's just a standard in the box, do not bother each other, that sort of thing. I don't have any issue with including language that neither party should be accessing the other's social media or cyber stalking or anything like that. I don't know that I have evidence that would support that, but that seems like a reasonable restraint. Obviously, the transfer of intimate images as would normally be required. Well, my thought is to include just an out-of-the-box restraint and the temporary orders. I mean, on a temporary basis on the debts, I think whoever's got a debt in their name, if there's a payment due, they should take care of that. But I don't know whether what's listed in this division of debts proposal is appropriate, because I have no idea what the monthly payments are on each of those and what the parties' incomes are. I am going to leave her in the home pending the next hearing. That's not a final decision on that. That's simply because it doesn't make sense to me to her move out, her move back, and her move back out, and potentially whatever I'm going to do at the next hearing. So I'm going to leave her in there at least until I get a better understanding of the finances. So do you want this over 1 week or 2 for the balance?
I'm fine with 1 week.
1 week's fine.
All right, so over to the 9th at
there
1
were 2
o'clock.
hearings that were set, one for today's date and one for the 27th of December. And what happened was Judge Evans, we were able to wrap all of the issues up at once and hear them. The issues that specifically were being heard were a presentation of orders, which I believe that was on for the 27th. Excuse me. And then I honestly do not remember what this specific hearing was for today, but I do know that if we look at the orders that were given, excuse me, last month by Judge Evans, everything was signed off on. If you can give me just a few minutes, I can pop down into my email and see the communication that was done between me and the other attorney in the case, and can see the orders that were signed off on and can report back to the court so we don't waste time.
It looks like nobody appeared on the
Oh,
27th.
excuse me. It was a motion for Ms. Pittman's motion for waiver on her GAL fees.
Right. And just one second.
And my understanding is that Judge Evans did approve of that, and it was ordered.
He
And I
did.
think there was some confusion about how it was worded in the order because it was Judge Evans was unsure if the GAL fees were waived as to the respondent or as to the petitioner.
Order was marked that they were waived as to respondent, but the petitioner was requesting it. So I let Judge Evans know that, and the parties know that we would need an amended order. I'm not sure if that's why this is on today. And that's
Okay.
just what I am aware of in the order.
Okay, good. The order that we have waives them for the respondent. And
That is correct. It was supposed to be ordered, they were waived for the petitioner as Ms. Pittman is the petitioner in this case.
just trying to see what happened at that last hearing. So on the 19th, he adjusted, he took the order that you provided, waived fees for the respondent. Struck the hearings for December 27th and today, it looks like. So this one should have been stricken, it looks like, from those notes. But maybe maybe it doesn't need to be dealt with, and there's another hearing, looks like on the 23rd, I believe.
Yes, yes, Your Honor, I do believe there is one. I'm not concerned with my client paying the fees. I just wanted to make sure that Ms. Pittman, it was approved by Judge Evans, and so I think there was just some confusion as to how the order was written, and he confused the petitioner with the respondent.
Well, if that's the case, then we need an amended order so that Ms. Corey knows what she's supposed to do.
Absolutely, and I can work with opposing counsel to get that done.
Okay, if you can forward that and just send it to my attention with the correction, I'll be happy to sign that.
All right, thank you, Your Honor.
All right, so Ms. Corey, you know what the order is going to say when you get the next one. It'll switch the parties paying, and then we'll be back on the 23rd.
Can I clarify, please? So
Sure.
the respondent will be private pay and the petitioner will be county pay.
I believe that's correct.
That is correct.
Okay, thank you.
So you'll get a new order.
Thank you.
Hopefully in a few days you'll see that.
Right, I'll watch for it. Thank you.
All right, and did
Okay.
you receive
Thank you.
Mr. Gall's
Thank you.
response?
I did, Your Honor.
Okay. So
Was that response timely to the court, Your Honor?
I think there was a note from the last hearing that it probably would have been late, but it was obviously set over to allow you to file that. So I'm assuming that that's.
Yes, I just wanted to make sure that the court did receive it. I believe
I did receive it.
You did. Thank you so much, Your Honor.
I did receive it, and it's in the court file. It's document number 186.
I appreciate allowing me to submit my response.
So I'm a little confused. And again, I'm coming into this case obviously a bit late into the game. It looks like you're asking to withdraw from the case, which the timing on that, I think, comes up pretty quick as far as your standard withdrawal, if I'm not mistaken. Is that right?
Yes, Your Honor. So actually asking for three different things. And first, so my withdrawal has nothing to do with my client whatsoever. It has to do with a disagreement about how it should move forward and interactions with Mr. Gall. Essentially, what my client is asking, and what I'm asking as well, on behalf of my client, is not only to allow me to withdraw, but to continue the trial. There are two trials set currently. We've already been bumped once. There's one that's in civil priority week. I believe it's in June. That was already June or July. That was already set by the court. Another one, which was coming up at the end of this month, and that was not in civil priority week. Obviously, if my client was to retain new counsel, she would need it pushed to the second one. My issue here, and I've already spoken with my client and gotten consent, is that the child needs to have an attorney appointed. It is essential in this case for this child who has a voice, who wants to use the voice. I am morally opposed to putting children on the stand. I won't do it. I don't, no matter what. I have an 8-year-old myself. I don't believe in it. This is where the disagreement lies. However, I do understand. I believe it is vital in this case. That's why I'm asking for a withdrawal. It has nothing to do with my client. It has everything to do with this little boy. That's where I'm at in there's this fundamental disagreement over how the case should go forward. Additionally, as I've stated in other hearings, I do fear any retribution at the end of this from the petitioner in this case. It is a concern of mine. It's been on the record before. There's a DVPO in this case. So kind of just to give a little bit of background, this case originally started as a domestic violence protection order. My client was granted that. It was re-upped. That was granted as well. My client fled with her children to Squamish, I believe, or I can never pronounce it. And Mr. Gall has had no in-person contact with the children for a considerable amount of time. There are counseling records on file. The children are in reunification counseling. I believe they only have video visits. My client would object to any hearsay statements. I don't see any declarations signed under affidavit or penalty of perjury from any of these people. Essentially, what you have is a declaration of Mr. Gall stating what he believes they would state. My client would state that that's not what would be said, or we'd have it before the court. We've got counseling records. We've got CPS records. We have police records. We have all of that. It is concerning that Mr. Gall still takes no stock in his actions being an issue here. Once again, this is made about me. Once again, I am the bad guy here as the attorney. The laser focus on me is one of the reasons I'm asking to withdraw from this case. I feel that it's not only mudding the issues, but it is personally concerning to me, given the history in this case. Mr. Gall has now asked for reunification fees to be paid out of, there's about a $20-ish thousand amount that's held in my trust. That comes from Mr. Gall in contempt of court, sold a food truck for $60,000. Judge Hahn ordered him to put the entire amount into his trust account with Kurt and Ignacio, his first attorney. He's had 3. And Mr. Gall did not do that. He spent $30,000 of it. He put the rest in. Judge Evans gave my client $10,000 for legal fees. Of the remaining 30, there's now whatever this 20-something amount in my trust account. My client is asking for 10 of that. Mr. Gall's already spent 30 of it. She's asking for that 10 in order to find a new attorney. Mr. Gall was ordered to pay reunification costs. He has not done so. So now he's asking for the additional 10 to pay for his reunification costs. This appears a bit disingenuous, considering it appears Mr. Gall was on vacation for the entirety of the last month. My client believes if he was on vacation, able to pay for that, why isn't he paying for his reunification fees? I don't believe child support has been paid this month. He's not paying much else. No spousal maintenance or anything of that nature. My client has essentially a minimum wage job. That's kind of where we stand today. Mr. Gall is highly educated. My client is not. There's definitely an issue here. Additionally, my client, being a victim of domestic violence, has significant issues putting together anything. And my concern is, if I am allowed to withdraw, and I do need to withdraw for personal reasons, if I am allowed to withdraw, my client, there is no way that my client will have the ability to present anything to this court, nor will she be able to be cross-examined by Mr. Gall. I believe it would be incredibly detrimental to her mental health, and it would just be a complete, there would be an inequality of power, and it would not serve the interest of justice. So essentially what we're asking for is that I be allowed to withdraw. But prior to that, Mrs. Gall be allowed to use $10,000 of the remaining funds in trust to hire another attorney to take this to trial. There's already been some ER 904s and some things like that, back and forth. That court-appointed counsel. He is of the age where he has requested it. I'm making that request on his behalf. It appears from Mr. Gall's documentation that he has no issues with that, and that finally, that the trial be moved to that secondary trial date, which is already on the calendar, which there's no need to go to a special trial set, and that the parties resolve it that way.
The child is 10 or 11?
I believe the child is 11 years old.
Has there been a guardian in this case?
This is where it gets really strange. This was handled originally under Commissioner Nelson in the protection order docket, including the family law. So there was a guardian ad litem appointed. I believe it was Ms. Corey, actually, who's here, was appointed in the protection order. And she was on that case for a significant amount of time. She did put in a final order into that case, and I believe we did file it in this case as well.
Your Honor, may I reply?
Sure, go ahead.
Okay. So, Your Honor, I believe that this isn't the first time that an attorney has taken their last effort to try to martyr themselves in effort to disengage with a client that they no longer agree with. As was made evident in my submissions for pretrial, I have presented to the court information, indisputable information that confirms that the respondent had lied to this court and misled them. All in addition, all with the assistance of Ms. Winkles, who obviously has a financial interest in this matter. I have no reason to deny Ms. Winkles departing the case. It's just the timing. While Ms. Winkles will continue to attack me and pretend that I am a bad person just so that she can try to get her way and not be responsible for the lies that have been documented to this courthouse, for which she will be responsible for at some point, then I want to make sure the court understands why these comments have been made. In Ms. Rosen's reports from a year ago, and again as of a few months back, there's contradictory information. These reports have been submitted to the court, and the only difference that has happened in that time is that Ms. Winkles has successfully manipulated the court to prevent me from seeing the children. Part of my evidence was to show the drastic change in the report. That one report showed progressive and exponential progress between the children and I, and that the last report showed a lot of regression from the children only while being exposed to the mother. Now, I have told this court that mother suffers from mental issues. Obviously, Ms. Winkles has just confirmed that. Now, these issues are starting to affect my children. My son has reported to the reunification counselor suicidal thoughts. My son has reported to me that he is so overweight that his health is of concern now, and he has to wear a heart monitor at the age of 12 years old, that he can't take 2 or 3 steps. This coincides with the way that my ex-wife manipulates the children. She feeds them junk food and lets them do whatever they want, even play violent and sexually aggressive games such as Grand Theft Auto, all while she's claiming that I am the bad person. And Your Honor, I was definitely looking forward to a trial on January 22nd, because this trial was definitely going to allow me to show everything that I held back on. I was going to bring witnesses such as police members. I was going to provide every report provided in which none of these allegations continue to support their false accusations. But now my children are suffering. They have tried to punish me financially. They've said that I have gone against court orders, but all I did was sell property, and I did take a punishment for it. I paid fees in return for that. This is a last final run for these trust funds. If the court has had the ability to submit my pre-trial documents, the court will know that there is an excess of $160,000 in negative equity, something with which the respondent will not be able to pay for. And they realize that, and they're trying to cash out on all this. I don't care who gets what. Material is material. I can restart all over. All I ask is that this be made fair, and that they're unjust and blunt lies to the court, which have delayed my reunification and obviously affected their well-being, both physically and mentally, be supported by allowing the respondent to become responsible for some of the actions that she has caused in the last 2 years and some of the protection that her attorney continues to provide, all because of her financial interest in this matter. She stays here, she stands there claiming that she's going to forgive everything. Well, that's not the case. She continues to collect on me and has made no comment as to the outstanding attorney fees awarded to her. So to what effect does she want to run away from this matter after she has made all these lies and accusations to the court, and after I have recorded evidence and submitted it to them? This mother is going to continue to injure the children. I'm sorry, sir, go ahead.
Yeah, let me ask you a question, sir. I got from your response that you filed that you're not necessarily opposed to her withdrawal.
I'm not opposed to Erin's withdrawal. No, I am definitely not. I'm just opposed to her withdrawal expeditiously because it won't allow me the time to serve the rest of the paperwork or my children to be served properly during this process. I also do not oppose my son having an attorney, Your Honor. I really feel that somebody that I can speak with rationally and like a regular human being, not being attacked by an attorney on the other side would probably be helpful for this matter. What I don't agree with is her to try to remove herself less than the court rules allow. Because I do plan on serving paperwork that will try to help the children and I continue to reunify in an effort to stabilize them. Your Honor, there is so much damage that has happened to my son in the last year, and the only influence is the mother and his mother and his grandmother, who is a noted racist and alcoholic. So I want to make sure that the court has this in mind to be able to make a decision that'll please allow the better interests of the children to provide the care that they need and the access. Had I known that this matter would require declarations from others and not the paperwork that has already been submitted to the court, then that's probably something that I would have done in that week that the court has allowed me. But the timeliness of this is obviously fishy. Her wanting to withdraw, it's understandable. She's been put up against the wall with some of her previous actions. And, the run for these trust funds, I don't mind that she has the funds, but please consider that my children are being damaged by mother and that they need to be stabilized again.
In Your Honor, very brief reply.
Sure, go ahead.
Your Honor will have the medical records of the child. The child was in the ER for a heart condition after being told that he would have in-person contact at some point with his father. So a lot of these things that are put on mom or put on me, the court can read. The counselor's records, the court can read the hospital records. They're all there for Your Honor to see. Again, this is why I'm withdrawing. Again, Mr. Gall makes this about me as the attorney. I have a real fear of what will happen should this case actually seek resolution. My client, when I say mental health, to attempt to make a mental health disorder from PTSD due to abuse, then suddenly a reason why, I'm not sure what the argument is. I'm just going to say this case has very little to do with me. The facts are the facts. There is a DVPO. There is a re-upping of that DVPO. Mr. Gall has not seen his children. This has nothing to do with me as a person. This has nothing to do with me as an attorney. This is the facts of the case as I present them from my client's mouth. The money that's in that account, Mr. Gall has the ability to pay reunification and should have been paying it the entire time. Ms. Corey's here. She is the GAL. She was involved in this case throughout a lot of it. If Your Honor wants to hear from her, I'm sure she'd have no problem. This is a case where it is necessary for my client to be represented as a victim of violence. It is necessary for this child to be represented as a victim of violence. Unfortunately, at this point, my choice of withdrawal has nothing to do with money. I've already agreed to essentially write off $9,000, I believe is what it is now, more after today. It's not about the money for me. It's about my own personal protection and well-being. And so I would ask to be allowed to withdraw. I'd ask to be allowed to disperse $10,000 to my client so she can find counsel. I ask, and I think that counsel needs to be male for a number of reasons that I believe are borne out in the declarations. I also ask that Kayla be appointed court-appointed counsel, and again, that the trial be continued till June.
All right. Well, looking at again, I don't have the benefit of having heard all of the various back and forth between this case. I don't know if I've previously heard anything on this case that I recall specifically, at least. I have checked with court administration to take a look at what the week of the 22nd looks like, just so I had an idea of what we were looking at. The chances of a 3-day family law trial going out that week is probably slim to none, just simply because it's set behind, I think at this point, about 22, I believe is what she said, criminal matters. Obviously, there's not going to be 22 of those going to trial, but they bump civil cases during criminal week. So the chances of it going on the 22nd is pretty small. That doesn't mean it couldn't, but there's certainly no guarantee of that. And that was probably indicated at the time we set the second trial. Sometimes we do that in hopes that it'll clear up. Given the circumstances, it seems appropriate, probably for everybody's benefit, that Ms. Winkles be, excuse me, I apologize, withdraw from the case. I am inclined, given the relatively short time between now and the trial, if I had an attorney sitting here, that might be feasible to leave it on, but it's unlikely to happen. So what I'm inclined to do today is to, at this juncture, strike the trial the week of the 22nd. I can put it back on a trial assignment, see if we can get a time sooner than the June date. But again, it would likely be, well, it would be set as a second set behind criminal matter. So you'd be in the same boat.
I would appreciate that, Your Honor, please.
We can do that. I can set it on and pick another day, but I'm going to set it out a bit so that we, well, let me back up a little bit more here. I'm going to approve the $10,000 to be, well, frankly, I think that needs to be, we need to have an attorney on board before that's determined. So that needs to go directly as a retaining fee to an attorney. At this point, I'm inclined to put the balance of those fees, if Ms. Winkles is withdrawing us, and she is, because I've approved that, those go into the registry of the court. Not inclined at this juncture to appoint counsel, but I would be inclined to appoint a guardian ad litem. I think, and if the guardian ad litem looks into the case and determines that is appropriate, representing 10 and 11-year-old kids is more of an art than a science, and it really depends on the minor and it depends on the attorney and whether that's going to be as effective as a guardian ad litem, frankly. So I guess my first two questions, it sounds like Ms. Corey previously worked on a protection order case.
That's correct, Your Honor.
And Commissioner Nelson transferred the protection order case to this case, Your Honor, because he realized it was being prolonged unnecessarily, that it should be.
My question is do you have an objection to Ms. Corey? And well, two things, Ms. Corey, I don't know if you'd be willing to take this case back on. Alternatively, do you have any objection to her coming in? She's got at least knowledge of the case, which would decrease the amount of time that would need to be spent by the guardian to kind of get up to speed. And her role really is to look out for the child's best interest. So,
I have a question. Ms. Corey, could you answer the court's question, please?
Ms. Corey, if you're willing, are you able to do that?
Yes.
Okay.
My only concern, Your Honor, is that Ms. Corey probably has not had as much communication with the children in the last year since she's been requesting to remove herself from this case as of the original rulings.
I understand that she's going to have some time to get back up to speed because if she comes in effective today, then we're obviously not going to trial on the 22nd. So she's going to have some time to look into the matter. And then she also could be present at a trial assignment to determine kind of what timeline she thinks she needs to get up to speed. And I think I'd like to have her talk to the child to determine whether or not, in her mind, as the child's advocate, whether an attorney makes sense. It very well may, but it's difficult with children of that age. That's a very that's right at the age where we start looking at appointing counsel. And I think depending on the maturity of the child, it may be more effective to have a guardian ad litem as opposed to an attorney. Attorneys representing kids of that age are kind of put into a Hobson's choice of how they handle the case, because it's on one hand, they're sort of acting as a guardian ad litem, and the other hand, they're supposed to be representing the interests of an 11-year-old.
Yeah.
So
I definitely agree with Ms. Corey coming in, Your Honor.
All right. So let's start with that. Ms. Corey, I'll appoint you. And I don't know, do you recall how your fees were paid the last time?
They were split half and half between mother and father.
And
Your Honor,
my clients were paid by county pay.
Your Honor, would the court please consider paying additional fees out of the remaining funds?
At this juncture, I'm not going to do that. That money's going to go into trust, and if it determines we need to have an attorney appointed, we may need some funding for that. Again, you've requested some money for this visit, the reunification counseling. I don't know enough about the case to understand what the current orders are as it relates to that, and I guess I'd want to know more about that before I made a decision. So that money would just simply go into the registry of the court, and if we determine down the line a bit that that's an appropriate use of those funds for either of those things, then we'll certainly consider that. But at this
Your Honor,
juncture, I'll enter an order appointing Ms. Corey under the same terms as the last order.
And Your Honor, if I just to be clear for me, since it's dealing with my trust account, I'm to disperse 10,000 when Miss Gall has counsel, and the rest of the money I'm to be putting into the court registry. Is that correct?
That is correct.
Would Your Honor please order Ms. Winkles to provide proof of that distribution when completed, please?
I think it's appropriate to provide documentation that the transfers have all been completed. Sure.
Absolutely.
And that can be filed under seal as a financial document with the court, I think, and copy, of course, to Mr. Gall.
One last thing, Your Honor. Part of what I've been fighting is a financial attack from both mother and her attorney. They've had prolonged events and extended things and regressed on progress. I am currently paying $1,100 a month in child support, which is current, contrary to Ms. Winkle's statement. And that actually leaves me at a negative $600 a month after my mortgage. All of my financial statements are made public to the court.
Okay, well, let me stop you right there. I'll be happy to take a look at those orders, but I need to have it done by a proper motion with supporting documents as far as finances and expenses and things.
To that effect, Your Honor,
if you want to file that, I'll certainly take a look at it.
Absolutely, I will file, Your Honor. But to that effect, would Your Honor please allow me to file and serve the respondent by email, just like I'm being served by email currently?
And I would object. We also serve by hard copy.
As long as we have an address where that can be served at.
So the respondent is 2.5 hours away, Your Honor?
Well, you could do it by mail, or there's a lot of ways that can be done. Mail is an appropriate service. It just adds a few days time to the
register mail. Okay.
Yeah.
Okay.
So, but yeah, she does need to be personally served unless there's an agreement otherwise. I think what I'm going to do as far as a trial assignment, my thought on this is I'm going to do this today. I don't know, Ms. Winkles, do you have any thoughts on how soon you'll be able to find an attorney? It wouldn't be done through the court, obviously, but.
No, I've already contacted 3 attorneys for Mrs. Gall. I hope to hear back today from some of them. So I asked to put this out 3 weeks. That should give that person enough time. Hopefully we can find somebody by that point.
And Ms. Corey, do you think you'd have an opportunity to speak with the child prior to 3 weeks from now? Assuming that's connections can be made?
Yes.
Okay, so let's put it on for the 24th. That's 3 weeks from tomorrow, Wednesday docket at 1 o'clock. And Ms. Corey, if you would be able to let us know prior to that docket or even at that docket whether or not you think it's appropriate to appoint an attorney, we can consider that at that time.
Can one of you give me the RCW with the points about a child having an attorney?
I can do that, Your Honor.
I'm not sure there's not a whole lot of specifics. It's whether you think it's going to be appropriate and useful to have an attorney representing as opposed to a guardian.
Okay.
It depends on the maturity level of the child. Real hard to represent a 2-year-old's wishes in court. And as they get 11 and older, it starts to become more of a doable thing.
Okay.
All right, so put it on, and I said the 24th at 1 o'clock. That'll be a Zoom trial assignment docket. And then we'll, I think that was everything that I can actually address today.
It was. Now orders, can we do presentation relatively quickly, just given the withdrawal?
You can, I believe. Let me just double check something here. I have to look at the calendar now because I have a new calendar and I'm not sure exactly what I'm doing when. How about, can you do it by this Friday?
I can, yes.
That'd be an 8:45 Zoom on my regular presentation docket. It's on our Friday calendar, or the link on that.
Your Honor, I'm not available Friday in the morning, so I'm traveling at that time.
Well, I could do the 12th.
I'm available the 12th, Your Honor.
And that works for me as well.
That's probably a little more realistic anyway. So we'll set it at 8:45 on the 12th. It's a Zoom hearing. To find the link for that, you go to our court website and the schedule will say Judge Bashor's presentation docket at 8:45. And if you get those documents, sir, and they meet with your approval as to what they say, not whether you agree with what I ordered, but if they say what I ordered, you're certainly welcome to sign off on those, and then you wouldn't have to be at that hearing. It's up to you, though. Okay.
Understood. Thank you, Your Honor.
Thank you, Your Honor.
12th at 8:45.
Okay.
All right, and we'll await orders. And I believe that is our, is that our, I think I see. So Ms. Winkles, you're not able to use audio?
I can use audio
Okay.
or video, but not both because I'm on a cellular thing. Unfortunately, my internet's down.
All right, audio is fine. I see Mr. Gall logged in. Mr. Gall, did you have a chance to take a look at the proposed orders?
I did, Your Honor. I got them late last night, and they were, I'm surprised. They just lacked some clarity per our last hearing. I just requested less than an hour ago for the respondent's attorney to clarify those things, but I haven't heard back from her yet.
Yeah, unfortunately, I don't have internet at the office at all. So I'm working off my cell phone. I don't mind any oral opposition or anything like that, just because I can't access anything.
Okay, perfect. Let me just read them out loud so that they can, for your consideration, see if they can go on the record. Give me a second.
I did note one correction. The trial scheduling date is the 24th, not the 22nd. So I have made that correction.
Perfect. So I just wanted to make sure that the funds, the $10,000 that are being awarded for additional representation, are to be distributed to the new attorney after the new attorney has made themselves available. This was specified by Judge Bashor.
And I agree with that, Your Honor. I noticed that after it went out.
Number two.
Here, hold on just a second. How about if I just add at the end of that 10,000 directly to the attorney referenced in number 7?
I'm okay with that.
Okay. I think it'll.
My second request, if I may.
Sure.
Okay. Is it states that I can serve the respondent, but I would like it to say that I was advised that I can also serve her by mail, which is important for me because of her distance.
And my only caveat to that, Your Honor, is if it's a contempt motion or any petition, it would need to be served in personally. That's why I put proper service. But obviously on service of motions, it's, it is proper service on
Right.
mail.
Right. Mail is fine as long as it's within this case. If you were to start a new case or something like that, it would have to be by personal service. But anything served and filed in this current case can clearly be done by mail.
Thank you, Your Honor. The last one is in our last hearing, I had requested the court to consider some funds for reunification. Judge Bashor had denied that request, but had left it open for me to make an official request with the proper paperwork, because apparently I didn't submit the right paperwork during my response. And so I just want to make sure that that's coming. That's all.
You would just simply need to file a motion requesting that with some documentation for it.
Okay, perfect. And those are all the changes I have, or clarifications.
Okay, then I will go ahead and sign these with those changes. I changed it's paragraph number 11 where it says universal trial docket that said January 22nd. I've changed that to the 24th.
Okay.
Which is that is the trial assignment docket. So
And absolutely my fault again. And my legal assistant was not able to review these because of the internet issue. So my apologies.
Yeah, that one. I only know because the 22nd is stuck in my head for other reasons as a Monday. So we've got that taken care of. Just 1 second here. Today is 12th.
Your Honor,
I did also notice it appears they struck the June trial and not the January trial. I'm not sure if that was an oversight or if that was meant to happen. I know that this is going back on to find if there was something earlier than that.
No, that shouldn't be. Yeah, that shouldn't have been stricken. So for my clerk, if we can double check that, the trial that was previously set in, I think, what was it? Do you remember the date, counsel?
I don't, but it was civil priority week.
June 18th.
June 18th. That should not have been stricken. The one for the 22nd is the one that should have been stricken. So if we can double check that on our record, we'll get that fixed. All right, so sign that order, sign the appointment of Ms. Corey. So that should take care of this case until you come back on the 24th for a new date.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Have a good day, and we'll talk to you later.
Thank you.